on the, Mr. Shire, if you can go ahead and make your announcement and give the style of the case that you're here on.
Yes, Your Honor. My name is Bill Shire. I represent the plaintiff. Syed Mustafi versus Chike Ahmadi is the defendant.
Okay, Mr. Jones.
My name is Ian Jones, and I represent the defendant, Chike Ahmadi.
All right, we're here on a motion to strike the counter affidavit. Is that correct?
Yes, Your Honor.
All right, why don't we proceed?
All right. This is a motor vehicle accident. The plaintiff treated with Dr. Marks for a period of time. He is a barber, had no health insurance at the time of the incident. Dr. McCaskill basically says he attacks the necessity of the treatment, and he bases that on what is known as the Official Disability Guide, or ODG. In addition, he talks about the reasonableness of the costs, and he based his opinions on Medicare reimbursement rates. So in order for the controverting affidavit, or in order for them to controvert, the basis for their the controversion must be something that would be admissible at trial. Now, the Official Disability Guide is used in nothing but the it's in workers' compensation cases. And as I put down in my motion there, the Official Disability Guides, it's a Texas workers' compensation statute. The publisher of the ODG guide, the Work Loss Data Institute, says that there are other valid treatment guidelines, and indicates that, there's other ways of doing this, and they're all valid. The ODG is used, in workers' compensation to say that a plaintiff only needs this amount of treatment or that amount of treatment. And because this isn't a workers' compensation case, it isn't governed by the ODG guideline, and it would not be admissible because it is not a workers' compensation. Dr. McCaskill, there's no Texas case or statute that supports the use of ODG guidelines in a non-workers' compensation case. And Dr. McCaskill doesn't state that the ODG treatment guidelines set the standard of care for necessity of treatment in non-workers' comp cases. So that's as to the necessity of treatment. And as to, it's interesting, Dr. McCaskill says, in terms of the reasonableness, he goes, while there's no definition of a reasonable charge for medical services, it's reasonable to assume that a reasonable charge would be consistent with the reimbursement that providers generally accept for a given service. The reimbursement is no more than twice that allowed by Medicare, because private insurance carriers do not, on average, reimburse for such services at a greater level than this. Well, reimbursement rates, first of all, don't set the, just because an insurance company doesn't pay for something doesn't mean that a charge isn't reasonable. But also, the case that I cite there, it's let me see, it was out of the federal court. Guzman versus Jones is what it is, and I attached it there. And it says whether an uninsured plaintiff who may have been eligible for insurance benefits but did not have insurance at the time of his injury is barred from presenting evidence of list prices he was charged by the hospital. And so what they said is that, he can present this. What a provider has a legal right to be paid is admissible, and that hypothetical insurance plans are not. And that's what we have here. Dr. McCaskill is assuming that there might be some sort of health insurance plan, and basing his opinions as to the charges on what a hypothetical insurance plan would allow. And in the federal court case, they said, no, there's no insurance. The guy gets to put on the full evidence of what the providers has a legal right to be paid. In this case, Dr. McCaskill has not stated that the provider doesn't have a right to be paid what is in the affidavits. So those are the two bases for the motion to strike.
Response?
Mr. Jones?
Oh, you're on?
Yes.
Yes. All right. Your Honor, so while the ODJ it does talk about work-related injuries as well as non-work-related injuries, but he doesn't necessarily base his entire report based solely on the ODJ. He also states the Occupational Medicine Practice Guidelines, the Cochrane Review, and guidelines from the National Clearinghouse, and he also states his opinion based on his own personal experience as being a medical professional. So not only is it not solely based on ODJ, he did look at the ODJ to help him come up with it, but it's not solely based on the ODJ. And in regards to the Medicare reimbursements, he's not necessarily saying that the reasonableness charges are solely based on Medicare reimbursement based on health insurance. He's just looking at the reasonableness as it relates to what a healthcare provider would be paid if they had health insurance.
Okay. So let's kind of break that down a little bit. So to the extent you're relying on the workers' comp rates, obviously I'm going to strike that, or Medicare rates, I'm going to strike that. But Mr. Shear, if he's also relying on just his own experience as a doctor on what the proper rates are, I think that's how it's always been done. I think that's allowable. Is that what he's done here or not?
Well, he has, first of all, with respect to the ODG, he says in his on page 6, he goes, the above opinions.
I've already ruled on that. You already
Very
won
good.
that. So,
Okay. In the charges, though, first off, you know, I don't know how Dr. McCaskill, usually orthopedic surgeons aren't sending out the bills, and they usually have a large office staff that does that. But his whole basis for his opinions in this is Medicare. He doesn't have any other basis for it. It's you know, he says Medicare, and then he goes at the state level. This conclusion is consistent with a published TMA journal article entitled "Private Carrier Physician Payment Rates Compared with Medicare." At a national level, he talks about again for an analysis. There's an analysis of private sector prices for hospital admissions. Well, in this case, there is no hospital admission. And so really, he's not talking about his experience with what bills are. He bases it all on what carriers have paid him, I guess, or have agreed to pay him. And it's all based on insurance rates. And again, the Jones case there, Jones versus Guzman, said, you know, you can't use that in a non-insurance case where someone doesn't have any health insurance. And so he's you know, they're trying to get the discounted insurance rates from someone who in a case where there is no insurance. Now, if this were a case,
I've already ruled that Medicare is not going to be allowed in the ODG, I think is what it is. The workers' comp rates aren't going to be allowed. The question is, I mean, you know, I will tell you how I usually analyze these is, but this isn't how the argument, you know, I look at Turner v. Peril, is the doctor of the same area of expertise on each. So a chiropractor could counter a chiropractor, an orthopedic surgeon could counter an orthopedic surgeon. You didn't raise Turner v. Peril, so so I guess McCaskill, I'm not sure what he's countering exactly, but he would be countering, I guess, all of it. So then I would look at, you know, does he have the expertise? You know, McCaskill's very experienced, and I don't allow billing records clerks. I don't allow, you have to be a medical professional. But then you got to look at, you know, how do they counter? I don't let them go by any of these national guidelines, but the way it's always been done, I was, you know, a practicing lawyer, plaintiff's attorney, just like you are, Mr. Shear, and way counter affidavits always have been done, and testimony's always been done. Are they familiar with the rates in the area? And that's kind of what Mr. Dr. McCaskill did, I think, in this case. One option we could do is strike a portion of the affidavit and then do counter affidavit or do dueling affidavits. Have you guys talked at all about that?
No, and I will tell you, Your Honor, he doesn't state that he is familiar. He does.
Mr. Jones said he did.
I'm looking at it, and he doesn't say he's familiar with billing rates in anywhere, and I don't see that. I don't see that in anything. I'm scanning through right now his affidavit. It just doesn't. It doesn't say that he is familiar with the billing rates. In other words, he's basing his opinion solely on this Medicare stuff and the printouts. He does not state.
Mr. Jones, is that accurate or not?
Excuse me. He states that based on a review of the record and his opinion that the reasonableness of it. Does he detail and say, based on my opinion, that X, Y, and Z was charged this amount of my practice? No, he just based it solely his opinion on his medical expertise.
Where are you citing to within it? I'm trying to pull it up right now. Did you attach? Great, I can't pull it up.
Go ahead.
Can you share screen? Okay, there it is. You said you've attached it to the end. Okay,
I attached it to my motion.
So what page, Mr. Jones, are you citing to here?
One moment, please, Your Honor. It is page. Page 6.
Okay.
And it is in the page 7, Your Honor. It says the opinions that I have expressed above have been expressed in terms of reasonable medical probability, and I reserve the right to supplement or amend these opinions as a result of my review of additional pertinent information.
Again, though, Your Honor, I did an OCR scan of this. He doesn't say familiar with the charges in the North Texas area. He doesn't state that he's basing his opinions on the reasonableness of the charges based on his experience. He doesn't state that he is familiar anywhere.
I don't see it either, Mr. Jones. Do you guys do that? Does Dr. McCaskill do that?
Does he do what, Your Honor?
What Mr. Scheer just said.
Does he base he doesn't specifically say that he bases solely in the report.
Well, that's what I have to rely on, right, is the report or the affidavit.
Right.
It's not in the affidavit, it's not in the report, correct?
Not those specific terms, no, sir.
All right, I'm going to go ahead and grant the motion to strike the counter affidavit then. All right, Mr. Scheer, go ahead and email my court coordinator a copy of the order, striking the counter affidavit. Anything else we need to talk about today, guys?
No, thank you, Your Honor.
Mr. Jones?
No, sir.
Thank you so much.
Bye-bye.
All right, Mr. Milligan, what are you here for?
Apologies, had to unmute. I am here for the Zubarik matter, sir.
Okay, well, let me see what time that is.
I didn't have a definite time. I'll drop off if we know.
Oh yeah, Zubarik.
Yes, sir.
Okay, you guys are not until 11, so.
Oh, heck.
I mean, you're welcome to watch all these hearings, but I'm not sure they'll be that interesting for you.
Well, no, I've got other things I could do. I just didn't realize we were on at 11, and I don't want to take up any more of your time. So I'll see you in about an hour and a half.
Okay. All right. Thank you, Mr. Milligan. Okay, so we're gonna play a little game, everybody. So everyone turn on your sound and your picture if you can. We're gonna play a quick round of intern Jeopardy, okay? So every team pick a spokesperson. Team 1.
I can speak, that's fine.
All right, Randy. So team 2. Who's going to be the
I can
spokesperson?
talk if they want to.
I couldn't hear that. Who
Oh,
said
sorry.
that?
I'm sorry. My thing, my little thing. I'll speak.
Okay, so Alexa, team 3. Who's going to be the spokesperson? Samir, you're going to do it? And then team 4.
That'll be me.
Amanda, okay. So this is going to be one question, and whoever gets this correct, everybody who's not a spokesperson, you guys go ahead and turn off your sound, okay? So only the spokespeople will have their sound on. Okay.
We can't hear you, Judge.
Wait.
Judge Hoffman, we can't hear you. Well, no, I don't think you can hear
Can
me.
you hear us?
Hey, Judge, we can't
I'm
hear
going
you,
to let you-
and we're still streaming. YouTube.
Oh, we're still live on YouTube.
I'm worried about some copyright laws. Maybe might be bad.